Today, the subcommittee begins efforts to modernize the Clean Air Act. The act was last amended in a consequential way in 1990, with Energy and Commerce Chair John Dingell being a driving force in that bicameral compromise. The Clean Air Act has been effective. According to EPA's 2023 Air Quality Statistics Report, since the Clean Air Act amendments were passed in 1990, there's been a 79% reduction in carbon monoxide, a 92% reduction in sulfur dioxide or SOx, and a 55% reduction in nitrogen dioxide or NOx. Since 2000, we've seen a 42% reduction in particulate matter 2.5, which are inhalable particles measuring less than 2.5 micrometers. The Clean Air Act's National Attainment Air Quality Standards, or NAAQS standards, setting and permitting programs with each new review. EPA generally sets with each new review, EPA generally sets new, lower pollution allowances, and over time, these newer standards have had the tendency to pass the point of diminishing returns. Accordingly, if you're an industrial plant wanting to build in this country, you may have to wait until another plant goes out of business and you can take over their permit. This is not a path for economic prosperity. Additionally, I don't believe that banning new industrial activity in the United States was what the authors of the Clean Air Act were aiming for. It was a tough compromise bill meant to have each state scrutinize major sources and think about air permit planning, industry concentration, and air quality in unfavorable geographic settings. The act was written to get industry to re-examine its operations and control pollution by investing in and implementing innovative technologies. It worked. But now we have to examine the law in light of little additional public health gain at the expense of paralyzing nationally important industries. And that health gain, and what I'm talking about, is the fact that we continue to lower the amount of pollutants allowed. We need to begin a modernization effort by examining draft legislative proposals to reform the out-of-date NAAQS process. As we heard in our recent full committee hearing, overly restrictive air regulations have curtailed some domestic investment in important semiconductor plants and data centers, which in turn could jeopardize America's ability to be able to compete in the global artificial intelligence race. One of the draft bills we are discussing today would improve the processes EPA uses to identify NAAQS, pollutants, and ceilings, and then for states to implement those new standards. Under the Clean Air Act's NAAQS program, the EPA sets standards for 6 criteria pollutants like ground-level ozone and particulate matter. Historically, the Clean Air Act required the EPA to review NAAQS standards and, if appropriate, issue new limits at 5-year intervals. The EPA has consistently missed statutory deadlines for both reviewing standards and for providing implementation guidance to the states, which has led to litigation in some cases. These proposals will enable more reasonable requirements that states can actually implement. That is why the Clean Air Act and Economic Advancement Reform Act that we are talking about today would lengthen that interval to 10 years and allow the EPA administrator to consider whether it was likely the standard can actually be attained. Additionally, the bill would require the EPA to consider the economic feasibility of these new standards. The bill would also allow for naturally occurring air pollution events such as wildfires not to count against NAAQS emission averages for a particular state. The other bill, the Clean Air and Building Infrastructure Improvements Act, has to do more specifically with the most recent PM 2.5 rule that really would cripple a lot of industry by reducing the limit from 12 micrograms per cubic meter of air to 9 micrograms per cubic meter of air. Further, it allows for an easier pre-construction permitting process. Protecting our environment and our economy do not have to be mutually exclusive goals. But in order to achieve both, we must rethink how our country classifies pollution levels outside of our control. The EPA is still in the process of updating various air quality standards. As that work continues, Congress must ensure states and employers aren't unfairly penalized by impractical or burdensome new rules which could hurt our national security and our economic competitiveness. I look forward to learning from our expert witnesses who have extensive experience in implementing and complying with NAAQS standards under the Clean Air Act.